I want to welcome everybody to our interview with candidates for the 5th Judicial Circuit, Group 20. In this race, we have two experienced attorneys who are both natives, Ben Boylston and Barbara Kissner Kwatkosky, who is currently serving as magistrate. And we are going to take a few minutes to ask them some questions and try to give voters an idea of what they can expect from both candidates in this race. And I'm going to start with the first question. The phrase judicial temperament is often used to describe those qualities that a good judge should strive to exhibit. Which qualities do you believe are most important for a judge to have the proper temperament? And we'll start with Ms. Kwatkosky.
Okay. I think judicial temperament is just the ability to hear cases and organize a courtroom and try to remain calm. I've been doing family court, and actually I'm going to take 10 seconds to correct. I had to resign to run, so after April, I am no longer a sitting magistrate, but I was a magistrate. Anyway, so in hearing cases, especially family cases, but it also happens in criminal and civil matters as well. Sometimes things get heated. Sometimes lawyers are zealous advocates. Sometimes self-represented parties are very emotional. Dependency cases, there's a lot at stake because the children might be in foster care, so there might be high emotions. And the ability to take a deep breath and focus on the law and not let the court's emotions take the best of them. I think that's what judicial temperament is, and it's a quality I strive for. Sometimes I'll have the whole courtroom take a deep breath to calm everybody down because everybody might need that. And if not, then everybody just gets a breath of fresh air. But I think that's what judicial temperament is, and it helps the entire court system work more smoothly. Thank you.
Thank you very much for that. Mr. Wilson, same question.
Thank you. I'm going to answer in a very similar way. I think that when judges become emotional on the bench, I think that's almost always a situation in which they've taken a wrong turn. It's very important for the judge to be detached from what's going on, to listen to both sides, and not get whatever personal emotion the judge might feel. And of course, judges are human. So it's not as though judges are capable of just not feeling any emotion. But certainly while you're on the bench and you're making the very important decisions that you have to make, that emotion has to be put to the side while you listen to the facts of the case and listen to the arguments of the parties and make a decision according to the law. So I think that's very important. And I don't know how much I added to the answer there from Ms. Kwatkosky, but I do agree with her. I think that's the most important thing as far as temperament goes.
A recent decision by the Florida Supreme Court regarding the word conservative could change the restrictions on what judges can say and hint about their political affiliation or ideology. What's your view of this decision, and is it changing the way that you campaign? And we'll start with Mr. Boylston.
Thank you. I did have a chance to look at that opinion. I have read it. It certainly has changed the way that I campaign in that, it made clear what previously was not clear. And that is that to refer to yourself as a conservative is not violative of the canons necessarily. I mean, obviously, if you just in and of itself saying that you're conservative is not violating the canons, and it's something that judge candidates are permitted to do. I do consider myself to be a judicial conservative. So it is something that I feel comfortable now saying because the Florida Supreme Court has given us the blessing to refer to ourselves as that. I do think it's important to make clear, and I always try to when I give speeches, to say that one is a judicial conservative, not necessarily a political conservative, because we're not supposed to get into politics. We are allowed to talk about judicial philosophy, not politics or political issues. We're supposed to stay clear of that, and I think that's a good rule. But I do generally, anytime the Florida Supreme Court can make it easier for us as candidates to understand what the rules are and the contours of what we're allowed to say and not allowed to say, I think it's a good thing. And so I welcomed that opinion from the Supreme Court.
Thank you. Ms. Kwatkosky, same question.
Well, I agree that anytime the Supreme Court or any higher court can clarify issues is welcome in any realm. With respect to that, allowing us to use that word conservative, I would agree with Mr. Boylston that you can clarify judicial conservative, meaning, you apply the law to the facts at hand in that case in maybe a more stricter way. I have tried to not use that word for the most part, although I do from time to time, as Mr. Boylston indicated, that definition. But so I agree with I will follow with whatever the Supreme Court has said and agree that any clarification is good for us.
I just had a quick follow-up that's sort of related. I know that recusals are an issue that comes up every now and then, and I know that recusals often happen when there's personal conflicts or personal knowledge of a case. I wondered what your thoughts were on recusals, and if it was something that you thought would be important if you had a difference from an ideological point of view or a subject matter point of view to a case that would come before you. And Ms. Kwatkosky, we'll start with you.
Well, I can tell you that I've been a hearing officer and magistrate for 18 years, and I've handled over 70,000 cases and decided 70,000 issues. I can't count on one hand the time of recusals, and usually it was somebody that I had a close relationship with outside of the court system and just didn't want the other party to feel like they might not get a fair trial. I have never once in any of those cases asked ideological issues, and of those, let's say 140,000 people that have been before me, assuming 2 people on each case, no one's ever asked me mine. It really comes down to the facts of the case and applying the law that's needs to be applied. I hope that answered the question.
It certainly did. Thank you. Mr. Boylston, same question.
Sure. I have absolute confidence that even if some party or litigant should have different political beliefs than I happen to have, or that should become clear in the course of a case, that I can put that aside. Because it's not about my political beliefs. It's not about the party's political beliefs. It's about what the law says. It's about what the facts are, and applying the law to those facts and getting the case as close to right as you can. You do your best. I can't imagine a situation in which I would need to recuse myself based on ideological beliefs or personal beliefs or anything like that. It's very difficult for me to imagine that. I serve part-time right now as the special magistrate for the city of Tavares. So I do preside over cases and issue rulings in code enforcement matters for the city of Tavares. I've had to recuse myself one time during the year or so that I've been doing it, a little over a year. And that was because a family member was involved in one of the cases and I had to recuse myself. But barring something like that, I don't see ideology or personal beliefs necessitating a recusal for a judge. Certainly in my case, I don't see that.
Lake County, a couple decades ago, actually more than that, was one of the first to adopt a model that's come to be known as specialty courts. They started a teen court. Since then, we've seen different counties take different approaches. Lake County does have, I believe, a veterans court. Other circuits or counties have adopted drug courts, mental health courts, homeless all kinds of specialty courts. If you are elected to the bench in Lake County, what specialty courts would you like to advocate that be added? And which ones would you personally like to serve on, if there are any in that group? And I'll start with Mr. Boylston.
Sure. I'm a Lake County native. I wasn't born here, but I moved here when I was very young. And I'm very familiar with the Lake County court system because that's where I've spent most of my time practicing. Marion County, which is where this seat may end up being, it's not really clear where we'll end up being stationed if we do win the election. It could be any number. It could be any of the 5 counties in the circuit, because circuit judges can practice in any of the counties. Marion County does a much better job than Lake County, in my view, of the specialty courts. I believe that Marion County has pretty much every specialty court that you can think of. Beyond Veterans Court, I don't know that Lake County really has kept pace. That's something that I'd like to see change. If I could focus on one, and that's mental health court. I recently had a client in Orange County Mental Health Court with severe mental health issues. And the level of care and attention that he got through the Orange County Mental Health Court system, it really helped him turn his life around. Getting that kind of everyone in the same room, the judge, a caseworker, a therapist, a psychiatrist, getting everybody in the same room to work on that problem. This is a guy who was living on the streets and was having a very, very tough time of it because of his mental health. And I saw firsthand just very recently how big of an impact that kind of court, specialty court, can have. We have a big problem in Lake County with mental health. People are recycled through the system over and over and over again because their underlying problem isn't addressed, especially with a lot of homeless people. The reason why they're homeless, not all homeless people, but a lot of homeless people, is because of mental health issues. So getting that addressed, getting to the root of the problem is a wonderful thing, and I think the court system should do more of.
Thank you. Ms. Kwatkosky, same question.
Okay. I will tell you about my experience with specialty court. When I was appointed as a magistrate in 2016, I was asked to restart what was called early childhood court, often referred to as baby court. In the dependency system where the state has taken children, they focus on the 0 to 3 age children in that family. And like the described mental health court that Mr. Boylston mentioned, there's a lot of resources. And the goal is, oftentimes in dependency court, you see parents that grew up in the dependency court have babies that are growing up in the dependency court that have babies that will grow up in the dependency court. And early childhood court is intended to break that cycle. And there's a lot of science behind that. So I was asked to restart that. And this was before the legislature had funded those positions. And I took that on. I agreed to do that. I also started early childhood court in Sumter County because once I saw that this is a great program and the potential is amazing, and having all of those people work together, I drank the Kool-Aid. I became a believer in those specialty courts. So I started that in Sumter County. I also supervised dependency drug court in Marion County. So those parents struggling with addiction had that extra time as well. I would love to see, and I know you mentioned Lake County, I would love to see early childhood court in every county in the circuit and every county in the state, because it's a great program. But I think as many specialty courts, it takes that extra effort, but it's worth it in every realm. I've never heard anything bad about specialty courts.
I wanted to ask if litigants and defendants here have adequate access to resources in terms of translation, interpretation for languages, and adaptive technology for people who are visually or hearing impaired. I know that perfect world kind of situation, you can't allocate those resources, but in a perfect world, is enough being done, and what more could be done? And Ms. Kwatkosky, I'll start with you.
Okay, so I was writing those 3 down because I know two of the answers. So Our circuit is very good. We have an entire interpreting department, and there are a wealth of interpreters. We have programs in each courtroom, so they have like this special iPad where they can do simultaneous interpretation. As a magistrate, since everything had to be recorded, we did one after another translation, but they were always available by Zoom or in person throughout the circuit. If it was, we also have sign language interpreters on as needed basis. And then we also have the language line. So that can be, I don't know, 200 languages that we can call and have somebody interpret. So I know we do a great job on that. With respect to hearing, we do have hearing devices in each courtroom. So those are available on request. And in family, I did a lot of Zoom court. So people were able to use their own resources. And I think that is helpful in kind of a different way. As far as visually, I'm not sure, honestly, what kind of resources we have. Although with Zoom court, there's a lot of documents that we can place up and increase the size and have that more visually. I have done orders in larger fonts on request so that people with visual needs can read their order without having to work on that. So I think our circuit does a great job at providing those resources to people. Thank you.
Thank you, Mr. Boylston.
I'm going to agree in pretty much every respect. I, as a attorney, I have to use our interpreting resources on a pretty regular basis, usually with the Spanish language, and the interpreters are fantastic. I think our circuit has done a good job of utilizing remote technology, which is a lot more efficient than actually having an interpreter having to come to the courtroom and bounce between courtroom to courtroom, which is how it used to be when I started my career. But now with Zoom or video technology that we use here, it's a lot better and a lot more efficient, and I've had a great experience with it. Same thing with the hearing impaired resources that we have. We have headphones and other amplifying technology to help people that are hard of hearing participate in the process. So I think we do a good job with that. As far as the visual side of it, I haven't had to use whatever resources we do have when it comes to visual impairment. So I can't really speak to that as much, but I think on the first two, at least, I would say we do a pretty good job at that.
Thank you very much. Technology has also been employed across Florida as one way to increase courtroom efficiency and keep cases moving. I would ask you, though, how do you balance the need to keep, to maintain a high level of efficiency with the fact that many of the people who are appearing in front of you are having pretty much the worst day or week or month of their life, and giving each case the attention it needs. So what kind of balance, if you were elected judge, would you strike in those cases? And we'll start with Mr. Boylston.
Sure. So, yes, I mean, and I'm a criminal defense attorney, so, I deal a lot with people that are having a rough time, whether the charges are legitimate or not, or, whether they made a mistake or whether whatever the situation is, it's not a good situation to be in the criminal justice system as a defendant. So, I'm very used to that, and I'm very sensitive to that. And yes, as a judge, you have to move cases along and you have to keep things moving, because what we see when that doesn't happen is that it hurts everybody. Nobody gets a fair day in court when the system gets backed up and we don't have time to adequately address cases. So yeah, that is a balance that has to be struck. It's a case by case thing. In a situation where a case deserves more time, yes, you give it. In a situation where the parties have been dragging their feet and the case needs to move, you need to light a fire under them to get that case moving. So every case is its own thing, and you have to look at each case individually, as far as what the history of the case is, what the nature of the case is, how long it's been pending, and make a decision as a judge as to what to do with it.
Thank you so much. Ms. Kwatkosky, same question.
Thank you. I was on the family bench when COVID hit. So we transitioned within a couple of weeks and started hearing cases. So that meant we didn't have a big backlog like other dockets. In my experience, the last 4 years since we've been using this technology, more people show up for family cases, and people are actually less emotional, I think. They're at home. I see their cats and dogs, or their kids, or they're just more relaxed. They're not sitting in the same courtroom or in the same space as this person that they're arguing against or battling with. It's also helpful, I think, that there's specific times. So somebody doesn't have to take off the day of work to go to the courthouse and find parking and go through security and all of those things. They can appear at 10:15 and be done. But the balance comes when it's either a longer evidentiary hearing that may require in person, or a trial that is required in person. But I think the balance is that any of those smaller hearings, and if it's easier, we have to remember that the court is here for the litigants. It's not my courtroom, it's their courtroom. So if people want to have a 15-minute hearing by Zoom, and they can both appear, then I need to let that happen and make that work for them. Thank you.
Thank you. We have actually come about to the time when we usually move on to closing statements. Before we do that, I'd like to let our readers know the Orlando Sentinel will be making an endorsement in this race. It won't be easy because we've seen, and today, as in many of the other judicial races, extremely qualified candidates on both sides. This is a very important decision for voters to make. Judges are sometimes the only elected officials that have direct impact on somebody's life, a family, the future of a company. There are many, many cases that come before judges that have a great deal of importance. So we do urge our readers, don't look at our endorsement as a mandate. Instead, we'd urge you to watch the videos, read our excellent coverage of these cases, visit both candidates' web pages, and just ask yourself which one of these people best represents my values. And there are so many resources out there, and we really encourage you to take advantage of them. This race will be on the August 20th ballot, and so we are going to be giving you as much information as we can. We will also be sending each candidate a questionnaire that will also be posted and hopefully included in a voter's guide. So with all of that, I would then ask our two candidates to wrap this up. Mr. Boylston, would you give us a 2-minute pitch on why you should be the choice in this case?
I really believe that when a person puts on a robe and takes the bench as a judge, it's not about them anymore. It's about ideas and principles that are greater than them. It's about protecting the community and protecting people's rights. It's about fairly and even-handedly applying the law exactly as it is, not how you want it to be, but how the law is. The law says what it says. I understand how important that is because during my career, I've been a lawyer for almost 20 years. I've had a lot of different perspectives. I've been a criminal defense attorney. I've prosecuted criminal cases very early in my career. I've represented crime victims. I've drafted contracts. I've represented small governments, small cities. I've done all kinds of things, including my experiences, as we talked about earlier, being a special magistrate for the city of Tavares, where I hear cases and I listen to parties and I make decisions. I have to issue orders. So, and I'm also a small business owner, which I think is very important. Not everybody that is seeking public office has that experience, but I do have it as someone who's been a public or a business owner for about the past 10 years. Gives me unique perspective that not only do a lot of public servants not have, but also a lot of judges don't have. And it helps them relate to a lot of the people that are going to be appearing in front of me who are also small business owners. So I think it's that diverse set of experiences that I have. Circuit judges have to hear all kinds of different issues, a very, very broad set of issues. I've seen pretty much everything that a circuit judge can see. I'm very well prepared to take this next step. And I would ask for the votes of the people of the Judicial Circuit in this election on August 20th. Thank you.
Thank you very much. Ms. Kwatkosky, same question.
Okay, thank you. I've been an attorney 30 years. I have practiced in civil, criminal, and family law. Since in 2006, I was appointed a judicial hearing officer. And in 2016, I was appointed as a general magistrate. A general magistrate's daily duties are really the same as a judge. I was assigned cases. I researched the cases. I prepared those cases. I set the hearings. I heard those cases. I wrote the orders and resolved those matters. In the last 18 years, I have heard and resolved over 70,000 of those matters in all realms, family, dependency. I've done mental health, Baker Acts, Marchman Acts as well. In addition, I'm on the faculty of Florida Judicial College, so every newly elected or appointed judge or magistrate has to attend this special training. I've been on the faculty since 2017, teaching cases or teaching newly elected and appointed judges and magistrates all kinds of things, handling self-represented, case management, contempts, working with interpreters. In 2023, I received the Faculty Leadership Award. So that is certainly one of the highlights of my career, giving back and helping with my knowledge that I've learned in the last 18 years. All of those new folks transitioning to the bench is amazing. And I'm proud to do that and lucky to do that. Outside of court, I've been married 28 years. I have 3 kids. My son graduated from the United States Naval Academy and is now a Marine. So I'm a Marine mom and we are a military family now. And I would ask for your vote on August 20th, Circuit Court Group 20. Thank you.
Thank you both. We wish you both the best of luck, and we really enjoyed spending time with you, and I will look forward to hearing more about your race.